everyone, and welcome to the purpose of juries and remedies in civil trials. All right, so today we're going to be looking at juries in civil trials, what they do, the fact there's only 6 of them rather than 12, and the strengths and weaknesses of them, which is just exactly the same as the strengths and weaknesses as juries in criminal trials. So that's going to be pretty easy. You've already got the table from that saved in your notes somewhere that you can hopefully just copy and paste across. If not, you're just writing the same things again, and that's a waste of your time, unless you like wasting time, in which case this is probably a good waste of your time. Then we're going to talk about remedies in civil trials. So the types of remedies we have, damages, different types of damages, and kind of like the specifics of them, and injunctions and what injunctions are and why they are used. So let's get right into it with our learning intentions and success criteria, and let's go for it. All right, so what we're trying to do today is know the role of the jury in a civil trial and the purpose of remedies. And the key skill for that is explaining the role of juries. So explain meaning that you should just be able to talk about what the purpose of them is, and discuss the principles of justice in relation to the resolution of civil disputes and remedies. So what we want to do is identify and explain use of remedies in resolving civil disputes and evaluate the effectiveness of juries in civil trials. So whenever evaluate's used, strength, weakness, and conclusion about that, chances are you're going to have to at some point respond to a question about that in general, where you have to give strengths and weaknesses. Pro tip for you, you've probably already read this on our team's post, unless you haven't. But your SAC for this is going to end up being just a quick research task where you look at a couple of civil cases and how they've been resolved, kind of similar to what you did with criminal law as the SAC for this, because tests in remote learning are kind of dumb. So we're going to do it that way. So the success criteria for that is that you can explain the role of juries in a civil trial, you can distinguish between the different remedies in Victoria, and you can discuss strengths and weaknesses of the jury. So when is a jury used in a civil trial? Well, in a civil trial, a jury is only used in the county court and the Supreme Court, trial division, and the party requesting the jury must pay for it. And juries are rarely used in civil trials. It's only when the people think they'll only win if they have a jury involved. The interesting thing about it, so no matter what, whichever side, the plaintiff or the defendant, if they want a jury, they have to be the ones paying for it. And it's kind of risky because if you lose, you're out of pocket even more. But if you win, then kind of the other party ends up paying those costs through the damages that they pay you. So kind of it's a real risk reward type situation. So the composition of a jury in a civil trial comprises of 6 jurors randomly selected from the electoral roll. So I've told the story earlier this year about when I had jury duty in Ballarat, and it was a civil case. It was in the county court. It was for a workplace negligence case where someone was using power tools without PPE. They got, I think, sparks from an angle grinder in their eye, and it negatively impacted their vision, and they were suing the business for not forcing them to wear PPE. And so they were looking for a jury of 6 people on that trial. And as I've always talked about when we talked about strengths and weaknesses of juries, in that trial, they were really trying to stack the jury with middle-aged white women who were nurses. So that's not a cross-section of society, because 4 out of 6 were middle-aged white nurses. And I don't think if you looked at society, that 66.666 recurring % of the population are middle-aged white nurses. So then the role of a jury in a civil trial, they decide on the balance of probabilities, which party's version of the facts is the most accurate. And the verdict can be unanimous, 6 out of 6, or a majority, which is 5 out of 6. And so juries must act impartially, so they can't be biased in any way. They must make decisions based solely on the facts presented in court. They can't do their own research. They can't go away and be like, well, I'm going to look up this person on Facebook or Instagram or on a dating website and see what they're like. They have to act impartially just based on what's being presented in court. That's only what they can make their decision on. And civil juries also determine the amount of damages payable to the plaintiff, except in defamation cases. So the judge can alter that a little bit. The judge can't alter the the liable or not liable side of things, but this jury will kind of come up with what they believe is a fair amount of damages to be paid. Jurors cannot gather their own evidence or complete independent research, like we talked about just before, and juries do not need to give a reason for the decision, which is always our greatest weakness overall. They just say liable or not liable, and there's nothing else. It's not like they're liable because of these reasons, it's just we think they're liable or not liable, and these are the damages. And that can be an issue because, well, what if they've made a bad decision? You kind of want to know the reasons why to know that they're not being biased in any way. So our strengths and weaknesses. The strengths of a jury in a civil trial is that they're independent, impartial, and unbiased. They allow for community involvement and allow community values to be upheld. Jurors can only base their decisions on the evidence presented in court, and decisions are made by a group, so it relieves the burden on one judge, because if you have a group, it's more likely they're going to make the right decision, because it needs to be that majority or unanimous decision. The weaknesses for that, juries do not give reasons for their verdicts, so we cannot be sure they've been fair in their deliberations. How good of a word is deliberations? It sounds so smart. It's just a fancy word for them talking. And jurors' tasks are difficult, so some members of the community find it hard to fill the role of a juror, and jurors can be swayed by skilled or persuasive barristers, and there may be biases or prejudices within the group. Then we get into the second half of what we're going to be doing today, the purpose of remedies. So the general purpose of remedies and all the things we talk about in civil law is all about restoring the plaintiff to the position they were in before the loss or harm was suffered. And this is often achieved through financial compensation, which we call damages, or an order for the defendant to act or not continue to act in a certain way, which we call an injunction. The reason why we do this is because often you can't actually return the person to the situation they're exactly in. So we kind of try and fix that with money or fix them with an action by the person involved. So for an example there, if there's a negligence case where you have broken your spine and you now can no longer walk and you're in a wheelchair, you can't go to court. They're not going to come to a verdict and be like, all right, you've got to fix that person's spine. That can't happen. It's not going to happen. So they've got to do that with money in some way. And then they'll work out a dollar value that kind of compensates them for the loss of their ability to walk, which putting a dollar value on that seems insane. But they attempt to do it in a way that will hopefully be able to counteract that loss that they've suffered. So our types of damages, which are the money paid to the defendant by the plaintiff, we've got a few different types here. You're probably going to need to go into them into a little bit more detail. I'm going to explain them for you. Purpose of your notes, you might want to scribble something a little bit with them. Our first type of damages are compensatory damages, which have a few little kind of subheadings underneath them. These are the most common types. So under these, we have a few different types. So special or specific damages, these are all about things that can be directly calculated and then given in the form of damages. So this is like if someone had medical bills, if they've lost wages, anything that can be specifically calculated to give back to that plaintiff who has been wronged in this situation. General damages are kind of pretty much like what they've said, they're general. They are things that can't be quantified. So it's kind of things like loss of enjoyment of life and like the mental impacts of the damages. So sometimes you will give damages for the fact that they've been mentally impaired by whatever wrong has been done to them, and that will fall under general damages. And then we have aggravated damages, which are kind of when they're given when they believe that the person acted in such a way that their actions were kind of ridiculous and they want to punish them for that. There are nominal damages. Nominal damages are all about where the judge believes that the plaintiff is in the right, but they also believe it was kind of pointless bringing the case to court, so they give them a tiny amount of money just to be like, well, you were right, here's a small amount of money, carry on. Exemplary damages are when they want to make an example of the defendant and they believe they acted in such a way they need to be made an example of, and therefore it ends up being a fair amount. And contemptuous damages is kind of very, very similar, but it's just when they believe the person acted in such a outwardly negligent or such a ridiculously, how am I going to describe it? So for almost the last thing that we're going to look at is the effectiveness of damages overall. So this all depends on several factors, including whether the loss was economic or non-economic. So economic losses are easier to prove and quantify, therefore it's easier to replace them. Whereas if you are suffering like from loss or you're grieving, A dollar value on that is like so hard to do. So like if there was a medical negligence case, or we won't say medical negligence because that ends up being a criminal case, but a negligence case where there's been a loss of life, you've lost a loved one, how do you put a dollar value on that? How long do you put a dollar value on that for? It's a tough thing to do, and they have to do it. If the plaintiff's injury is permanent, it's harder to quantify as well. So like loss of wages for the rest of their life potentially. And that doesn't, how do you factor in like career changes, promotions, all those kind of things where they could end up earning more money? Not to mention then all the other things they can't do because of their injury. Maybe they can't ride roller coasters anymore. That would be pretty sad. That would be upsetting. For me, it'd be more like if I couldn't go like out and explore nature. I'd be like, what? Give me money. It's also possible, it is possible to accurately estimate future loss that can affect how much damages are given, and the court is prepared to compensate the plaintiff for time, stress, trauma, and inconvenience, and the defendant has the capacity to pay the damages. So if the defendant can't pay the damages, well, then it's pretty ineffective because they either have to set up a payment plan or they've got to find another way to go about it, in which case you might not ever get those damages, which is not great because you want to be restored to your original position. Lastly, what we're going to look at are injunctions. So injunctions are an order, temporary or permanent, for the defendant to do something or refrain from doing something. So it either forces them to complete an action or prevents them from doing an action. They can be mandatory or restrictive. So mandatory meaning we're forcing you to do something, restrictive meaning you can't do this anymore. So how effective are injunctions? The effectiveness of an injunction will depend on factors such as if the actions have already caused a lot of damage, if the defendant will comply with the injunction, because as we've seen from curfews, etc., being put in place in Melbourne, people don't listen to things that are being told to them that they legally have to do. Like, why are you out after 8 p.m? I needed nuggets. No, you didn't. No, you did not. You are just a selfish individual who cares only for themselves. The plaintiff will actually be restored to their pre-infringement position. That's kind of important. So like, otherwise it could be too late. And therefore the injunction won't actually be effective. So what's the point of doing it? So these are injunctions. So injunctions forcing someone to do something or forcing them not to do something. Mandatory, forcing them to do. Restrictive, forcing them not to do. All right, so what you're going to do now are these Ed Rollo questions. It seems like a lot, but we've got a double period. And the first half of each of them are multiple choice. So there's only really 5 short answer questions for you to do. 5. Other than that, enjoy your day. I hope you have a excellent day. It's going to be, Friday? It's going to be nice, warm, but windy weather. Other than that, I will hopefully see you soon. Next week, we're going to be studying our assessment for this area of study, so be prepared for that. It's not going to be that bad. I'll give you all the details for that on Monday. Have an excellent day. Goodbye.